All right, we're live. My name is Attorney Vincent Davis, and this is the show Relatives Fight CPS. And I'm joined by my co-host, Georgette Truin, and tonight we have a very special guest, Dr. Tanya Fowler. Am I pronouncing that right, Doctor?
Yes, you are. Thank you so kindly.
Thank you. I'm an attorney licensed here in California, and I primarily practice in the area of CPS cases. I'm the guy you would want to call probably if you're trying to get your kids back, or if you're a relative in this case, trying to get the child out of foster care. And I've been doing this for 35 years as an attorney 35 years as of this December. So, Georgette, why don't you give us a little introduction about yourself?
My name is Georgette Truin, and I am the co-host for Relatives Fight CPS, and I'm an advocate for all people, actually.
Okay. And
I am also a survivor of CPS as well.
Okay, very good. And Dr. Fowler, could you give us a little introduction?
Thank you so kindly. Yes, of course. My name is Dr. Tanya Fowler, and I am the maternal grandmother of a 10-year-old boy who has been placed with CPS. We call it DHS here in Pennsylvania. And I have been blessed to appear on your show to discuss that and ask some questions and find out more about how to have my grandson returned to myself for kinship care.
Okay, well, this is the right show for you, Doctor. So why don't you go ahead and ask me the questions that you have?
Oh, certainly, of course. Do you mind if I just make one little statement before the question?
Absolutely not. Go ahead.
Oh, of course, yes. Just to give you a little bit of background, on May 15th, 2021, I received a telephone call from Philadelphia Police along with DHS here, Department of Human Services, informing me that my grandson was at a children's hospital. His mother had been psychiatrically hospitalized. We call that a 302 involuntary commitment here in the Philadelphia, Pennsylvania area. I went to the hospital to get him. I brought him to my home. Within an hour, DHS was at my home informing me that they had investigated me and I had, cleared, and that they were going to award me kinship care of my grandson. And they did. And for the next 6 weeks, he lived with me. Then on June 21st, that was a Sunday, when we were at a park having Peace and Love Sunday, it's something we've been doing for 30 years, worship and family fun, my daughter appeared. She interacted with the boy, and then she absconded with him. She just took him by the collar and took him out of the park. I'm abbreviating this. The next morning, DHS came to her home and with the police, breached the doorway, chased the child upstairs, and put the child into foster care, which is where he is at present. We didn't have an adjudication hearing. I had counsel at that time, and counsel had asked the court for custody for myself. The court did not hear the custody motion because the court said that they had to adjudicate first, and that I did not have standing for custody. The actual request, I realize now, should have been just to have my grandson returned to me for kinship care. The agency blamed me for the other person absconding with my grandson. And the status of things right now is here I am on your show and still wanting to work effectively with legal counsel. So my first question, thank you so much for entertaining it, is I cite in Pennsylvania 42 PA CSA 6332, which is the statute under which my grandson was placed with me. It recognizes me as a family member who can assume kinship care in a dependency matter, and when certain other conditions exist. Under this ruling, my grandson was first placed with me for kinship care. What do I do as a grandparent to get my grandson released from the foster system and returned to me for kinship care?
Okay, so that's the $64 question that most relatives have for us that call and talk to Georgette or me. So let me give you this disclaimer first. I'm licensed in California. I'm not licensed in Pennsylvania, although one of my attorneys that works for my firm is licensed in Pennsylvania. She's originally from Scranton, Pennsylvania. I don't know if that's near you or not, but if you were in California, and I would assume that it's similar, if not the same, in Pennsylvania, but you've got to check this with your attorney. The first thing that you would want to do is you would want to file what California calls a 388 petition. Now, it probably has another name, but it's in Pennsylvania, but it's basically a petition to the court to change an existing court order. And I'm told that the 388 is allowed or required under federal regulations. That's why I believe that Pennsylvania probably has a similar statute. And they probably have similar forms that you can use to fill out most of that 388 petition. Not all, but most. So a 388 petition in California is a request. It's a formal request. It's a form, about 4 pages, that you fill out. The deal, though, is you have to provide additional evidence by way of declarations or by way of other documentary evidence, including pictures and videos, to support it. And you probably want to include points and authorities regarding it. Now, it just so happens that tomorrow morning I'm going to be in a county here in Southern California arguing what's called the prima facie hearing for a 388. So in California, once you file the 388, the judge can decide whether to give you a hearing or not. Judge could say, no, you don't get a hearing. If the judge, and that's called the prima facie hearing, if the judge says, yeah, you get a hearing, then there will be a subsequent trial, probably on another date, and you're going to have to win that to win the case. You could get a hearing and still lose, right? Or the judge could say, no, I'm not going to give you a hearing. If the judge says, no, I'm not going to give you a hearing, or you have a hearing and you lose, those are subject to appeals in California. I would guess Pennsylvania would be the same, but you got to check with a Pennsylvania attorney that practices in this area. So that's the first thing that I would do. The second thing that I would do, and this would be fact dependent on your relationship with the child prior to the case being filed. And even, you said you were the caretaker for about 6 months or 6 weeks. What did you say?
It was 6 weeks.
Okay, 6 weeks. So you have the right to file in California something called a de facto motion. And a lot of times I hear people say that you have to prove during the case that you took care of the child, and that's not true. You could have facts that would support a de facto motion in California that occurred prior to the case even being started. So in other words, your relationship with the child before the case started means a lot. The next thing that you might be able to do in California, they've recognized that children can have more than 2 parents legally. And as a matter of fact, in California, and I don't think this is like this in your state, but in California, there are 5 or 6 different types of fathers that are legally recognized fathers. So, how can you have 5 or 6 different types? I thought, biologically, a father is a father, but that's not the law in California. That's one of the types of fathers, but there's other types of fathers. So you can file something for something, it's called presumed parent status. Now, I don't know if they have anything like this in Pennsylvania. You would want to check, or if they have something similar. Basically, it's a petition that you would file, and most of the time there'll be a hearing, if not a mini trial, where you'd have to adjudicate and prove that you should be treated as a parent and given the rights of a parent. A lot of times these cases come up in this situation. Mom is married to stepdad, all right?
Yes.
Stepdad is raising the kid for the last 5 years. A case is filed against the mom. They notify the biological father, and he comes into the case with mom. But stepdad isn't really a party to the case. So he would probably, if he wants to be, probably make a motion or a petition for presumed parent status, because he would come into court and say, look, judge, I'm the guy that's been taking care of this kid for the last 5 years, both financially, psychologically, and physically. So I should be treated as a father. I should be a presumed parent.
Mm.
And in a lot of cases, depending on the facts, the court may be required to acknowledge him as a presumed parent. And then in that case, you'd have a mother with two fathers in the case, each having their own rights to the child, their own rights to custody and visitation, and their own arguments to make before the judge. Now, that doesn't guarantee that the judge is going to give you the child, even if you are a presumed parent, but it's your first step into the door. So that's the second thing that I think that you should file. The next thing, or the third thing, the next thing that I would file is something called, in California, something called a petition for legal guardianship and petition for temporary guardianship. Now, here's the interesting thing. A lot of people give me flack about that, saying that it's no good. And over the years, some judges have recognized it, few and far between, and some judges haven't. Now, interestingly enough, the case I'm going to on tomorrow, I did this, and they actually set the petitions for guardianship on calendar. A lot of times I just get them and the clerks just tell me, oh, that was denied, Mr. Davis. You can't file that here in juvenile court, which is not true. There's actually a case that says that you can. I don't argue about it because it's, sometimes redundant, but that's what you also should do. The next thing that you should do if you were in California is you should file a petition to disclose the records. All of these records are confidential by law. And I think that's by federal law and federal regulation. So you might go into a case where there's reports about the kid, about the parents, about you, that you'll never be able to read or see because your petition, you didn't file a petition, and if you did, it wasn't granted. Years ago, I did a case in San Diego for some relatives, and I filed a petition to disclose the records. There were all kinds of social worker reports against my client, right? The judge denied the petition, and I had to do a trial where I couldn't even see the evidence that was being used against my client. Is that, how crazy is that?
Mm-hmm.
Right?
Wow.
So that's the next thing that you would want to file. And you would want to talk to your attorney in Pennsylvania to make sure that all of these things or similar things can be done. Now, here's the other thing that I've been telling people to do in the past year or so, because I actually read a case and saw the letter sent out where the Department of Health and Human Services took action against a county in California. And it was a case where a mother had lost her kid, and the social workers refused to place the kid back with the mother after she participated in the plan, and refused to place the child with the grandmother. Well, the mother, as a last-ditch effort, filed a complaint with the Department of Health and Human Services in Washington, D.C. Lo and behold, they pick up the case. Now, during all of this time, the kid actually gets adopted by a foster parent.
Mm.
All right. And the Department of Health and Human Services does their thing, writes a report after an extensive investigation by a nationally renowned social worker and psychologist, and concluded that this county, messed up. That the kid should have been placed probably back with the mother, but for sure should have been placed with the grandmother. But it was kind of too late because, well, the kid had already been adopted. So as a punishment, DHH says, well, we can't override what the court has already done. But if the kid doesn't end up back with the grandparent and the mother, you're not going to get any federal funding. Guess what happened?
Oh, I can guess.
Yeah, kid went back to the grandmother and the mother.
Oh, I see.
An extreme case, right? I wouldn't have believed it had I not read the letter from the ruling from DHHS. And they also filed a complaint with the Department of Justice Civil Rights Division, and those two investigations were combined. And apparently they can be combined by law for, efficiency. And so, the federal agencies wouldn't make conflicting findings. So those are two other things that you can do. And by the way, these things are treated very seriously. I advised a client to do this up in Northern California, and CPS in this particular county, and I think all counties, has a federal civil rights officer or worker, and that's all they do. And she came to court one day knowing when I was going to be there and asked me to step into a room, and she wanted to interview me about the case. And even though she worked for CPS, I didn't get the impression, which I usually do, that she was for CPS, for her employer. She was kind of acknowledging, well, they may have screwed up here and violated this family's, federal civil rights. And these state agencies, these CPS agencies, are very concerned about not doing that, not only violating rights of citizens, but there's a lot of money involved. And these agencies, federal money funds all of this. And if they want to play with the county or the state's money, believe me, that gets the state's or the county's attention. I don't know what the budget is in your state or county, but I've heard that Los Angeles, now that's a big county, I've heard that it's like $2 billion a year.
Mm-hmm.
If you started counting right now, doctor, by the time you die, you wouldn't reach 1 billion. That's how much money. That's how much money it is, right?
Understood.
So those are two other things that you can do. Now, that's the good news. The bad news, it takes a lot of time to do all this. The second bad news is you probably don't know how to do that unless you're a doctor of law and have experience.
Exactly right. That's why I'm pleased to join you on your show to find out more and how to better work with my counsel.
Right. So, what I would do, and what I do in these situations where you have an attorney, have him or her call me. I'd be happy to discuss this with them. And I get something out of it usually because I say to the guy or gal, hey, I'm going to help you. But in return, I want you to come on one of my shows and talk about representing people in CPS cases in your state, which would be Pennsylvania.
Oh.
Right? So I get a lot of attorneys, that want to do that because they want to help people like you. And look, it's just good for business. Right?
Yeah, but a lot of attorneys also, Vincent, don't want to do it.
I know. A lot of, it just depends.
Mm-hmm.
It just depends. There are attorneys that will do it, and there's a lot of attorneys that don't want to do it for many reasons.
Mm-hmm. Mm-hmm.
Many reasons. I have another show that was on last night, and in that show, after the show, the co-host texted me about two attorneys that wanted to come on the show, but they wanted to disguise their voice and not show their face.
Oh, I see.
I said, I was a nice guy. I said, well, I'll do it. Okay, well, if they want to do it. But you see where we are? Because a lot of attorneys fear retribution.
Oh.
Right?
Wow.
Hey, let me answer this question. Kelly Jean, I don't have an associate in Scranton. She's from Scranton, and she's licensed in Pennsylvania. And her name is Attorney Carol Batis, and she works for me.
Oh, thank you.
Okay, now.
But what about Vincent? Real quick, can't you practice law in another state? Can't you go to another state with the Pro Hoc Vici you were talking about?
Yes. Yes. So, although I'm not licensed in, say, for example, Pennsylvania,
Mm-hmm.
I can represent people in cases there by applying for something called Pro Hoc Vici, which just means hey, Mr. Davis is a good guy from California. He has experience. And can he do this case in Pennsylvania? And most states say yes, without, with very minimal documentation, as long as I get an attorney in Pennsylvania to assist me, and they call that the local counsel. For example, I'm doing a case in Oregon, and I have 2 local counsel on my side, so it's a legal team of 3 lawyers, me being one of them. And I'm not licensed in Oregon.
Oh, I see.
But I just have experience in the CPS realm.
I understand.
Okay.
Thank you. Mr. Davis, do you mind if I ask you another question?
Sure, go ahead.
Thank you ever so much. First of all, thank you for explaining these new petitions to me. It's all new to me. I'm very appreciative of your rich information. At a certain point, I had been strongly advised I talked to a lot of lawyers about this. And they all at first told me that I should apply for custody for my grandson. Some said I should apply for emergency custody. And others said that I do not have standing for custody, that the court, of course, would look first at either of the parents. The father in this case had not been involved before. I found him, and I hired counsel for him to have my grandson discharged to him. And that same counsel was also going to represent me too. In other words, the counsel was going to go to court for us, Dad and Grandma, ask the court for custody for Dad. And if the court didn't grant Dad custody, or if that was still going to be a pending issue, ask the court for having my grandson return to kinship care for me. And but that counselor, or that attorney, also ahead of time called, or he spoke with the guardian ad litem for the child. I think that's the attorney for the child. He spoke with the attorney for the mother, and the court appointed attorney for the dad, and was able to conference with them and engage in agreement. And Dad, one of the reasons why it didn't work out was because Dad defected. He just disappeared and wasn't available for the home inspection and things like that. And that's when things got unraveled. Thank you for listening to that. So my question would be, do either of the parents have the ability to surrender their custodial standing to me, so that we reduce the number of people who are contending for custody? Okay, I see you shaking your head no. Okay.
Well, at least not in California. I don't know about Pennsylvania, but assuming Pennsylvania is like California, no.
Okay.
Once the child is part of the juvenile court, they're a ward of that court. And what the parent does or doesn't do is of little consequence. Now, they could have done it before the case started, right?
I see. Of course. Understood. Thank you. Well, would there still be an opportunity through case conferencing, for example, for my attorney, over and above the motions that you just mentioned, to conference with the city solicitor and the lawyer for CPS and strike an agreement, instead of just filing and doing things the more formal way, through the court?
I don't know. You're really asking me the wrong question. Look, anybody can talk to anybody, but that doesn't mean you're going to get what you want. So the question really should be, what's the likelihood of my attorney just talking to these people and getting the kid placed with me? Probably very low. Because if it was just a matter of doing that, you'd have the kid already, right? It would be easy. You wouldn't be on the show.
Understood.
What I would recommend is that after you talk to your attorney and you file whatever motions and petitions you guys deem it to be necessary or smart to do, once you file and serve those, then you contact the other side and say, hey, I filed all this stuff. You're going to have to oppose it. We're coming in hot on this case. Did you want to talk about anything? Did you want to try to resolve something? And by that time, maybe, your complaint to DHHS in Washington, D.C., they've sent a letter to the local CPS people there in Pennsylvania. Like, what are you guys doing?
I see.
Right.
Thank you. Yes, of course. So it sounds like you've got to go way outside of their jurisdiction with these other.
Not necessarily. It's like it's an attack on a problem in different directions. You got a plan A, but you got a plan B, you got a plan C, and you got a plan D. Right? The more pressure you put on the problem, the better for you to get what you want. You increase the probabilities. Now, that doesn't mean that you're going to win, but we're talking about increasing the probabilities of you getting the child placed with you. Here's the other thing that I tell people, and I told somebody this earlier today on the phone. If you really are concerned about this kid being in a foster care, you should make a list of 25 people, friends, relatives that live anywhere in the world, not just Pennsylvania, in the world. Your name should be number one, but that should be given to the social worker through your attorney. But of course, discuss it with your attorney and saying, look, if you don't want to give the kid to me, place it with one of these people.
Oh, I see.
Right.
I would never have thought of that. Thank you.
Right.
Because
It's just so simple, right? You never would have thought of that. And I've heard tell that sometimes that once somebody on that list gets the child and say adopts the child, they might give that child to someone else. Now, I'm not saying that's legal or kosher, but I've heard that happen.
Thank you. That's very insightful. Before you had, and this next question, if you don't mind, might seem a little bit redundant based on the information you've just given me, but it was one I had already written out. And this has to do with, I was watching one of your shows, and you mentioned, please forgive me if I'm not quoting this correctly, 42 USC 1983?
Yes.
As a way to sue CPS for constitutional or what I call or civil rights violations. And my question was, do you think that a person such as myself should investigate that possibility?
Hard to say because I don't know enough of the facts in your case. I mean, initially it just sounds bad, but if you can get a civil rights attorney to review what's happened, he or she can give you an opinion on that. Right? And maybe you can do that, he'll do that, or she'll do that for free, or maybe at a very low cost that you can find out.
Thank you. It's also extremely helpful to know that there is a way to recall the record, because I feel that the agents have said things that would tend to assassinate my character or make me seem like I'm less than a responsible caregiver. And I wanted to be able to see what they said, what they scribed into the record.
Right. And you will only do that if you're granted a petition to what in California called the 827, and that's to disclose the records to you because they're confidential.
Thank you.
Okay.
Yes, thank you.
Do you have any other questions, Doctor? Because we have to move on to our next guest.
I don't have any questions, but I would like to express my deep appreciation for you, your staff, your supporters, and like all of the wonderful people that you've helped and that you've uplifted. Thank you ever so kindly.
Well, thank you, Doctor. And please keep in touch with us, with Georgette and myself, okay?
I absolutely will. I've been an avid viewer of your videos, and I pass them around to a lot of people. So you definitely have a strong viewership here in Pennsylvania.
Well, great. That's good to hear. All righty.
And Georgette, all the best to you.
Thank you, sweetheart.
God bless.
God bless you.
Thank you, Doctor.
Thank you.
All right. What a nice lady. Okay, we're going to go to our next guest. Our next guest is Crystal, and I'm not going to butcher that name. How do you say the last name?
Quartz.
Quartz. Okay.
Yeah, like quartz crystal.
Crystal Quartz.
Yes.
What state are you from, Crystal?
I'm from Tracy, California, in San Joaquin County.
In what county?
San Joaquin?
Oh, okay.
Yes. But the case is based out of Fresno County.
Okay.
That's where jurisdiction is.
Okay. Two counties I'm pretty familiar with.
And
Have a
then
third.
also involving Alameda County, where the father resides.
I have a trial coming up in a few weeks in San Joaquin County.
Oh, really? Well, then
Yeah,
you would
right
be-
there in
Very
Stockton, in
Yes.
that beautiful new courthouse they have there.
Yes, it is actually very nice.
All right, so Crystal, tell me why you're here tonight. What's going on?
So I had my nephew placed with me for when he was born. He was born under the influence, intoxicated, and CPS took him from the hospital, placed him with a foster parent. And then a day after, he was placed with me before court. And then I had him for 18 months. And during this time frame was the pandemic. So we were sheltered in place. There was 3 potential fathers. So we had to go through some DNA testing and found out who the bio father was in March. And when that happened is when we were put in shelter in place by the federal government. So we started doing virtual visits twice a week with Dad. And in this time frame as well, when I found out who the father was, I did know the background that the grandmother was trying to get guardianship, paternal grandmother, and that their house was on Megan's Law. So that kind of brought a red flag to me because I know me going through the RFA process that Megan's Law is going to be checked in the background search. So I brought that to the social worker's attention, making sure that I wasn't putting the child in danger if we were doing visits with paternal grandmother. And then also if that was the case, paternal grandmother was willing to move out of that home to her mother's house. The social worker expressed to us that she would not be dealing with that Alameda County, where the paternal grandmother lived, would be the one approving or disapproving of the home. So she was leaving it in Alameda County's hands, but did okay that the child go to this home and be watched and babysat while I returned to work. Father and mother, well, father did his services or attempted to do his services as much as possible through the pandemic, which was very difficult because 1, Fresno County is 3 hours away from Alameda, and then 2, nothing was opened during the pandemic, so it was all virtual. My sister, maternal mother, had mental illness, so she didn't participate in any of the court proceedings or services that were granted to her. Then we had the reunification hearing, and Dad was denied reunification because he had not finished his services in the timely manner. So that was my first question. Is there any legislation that's been put into place as to the time frame of completing services during the pandemic, or if there was an extension of time that they were able to be granted and reunification would still be an option?
That's a very good question. I'm getting that a lot, just because of the pandemic and the time, the time frames. Look, I don't know how to say this, but I get the sense that everyone wants to sweep that under the rug, that issue.
Mhm.
Like, oh, because it's really going to cause a lot of problems, could cause a lot of problems with the whole judicial system and the processing of these cases. Now, I seem to recall some rule, or there was a case regarding the COVID pandemic that was favorable to the parents in the computation of reunification services. But, and here's the big but, if you're going to make that argument, you and your attorney have to bring it up at the trial court level.
Okay.
If you don't, it could be deemed waived.
Okay.
Now, I don't think we know, we've seen all the cards on the table about what's going to happen with these COVID type things. And someone told me there was a lawsuit in a county about issues similar to what you've mentioned, some type of federal lawsuit. And you know what, I was thinking, I go, yeah, that's a great idea, because, a lot of people are getting, screwed. And, it's really up to the person and their attorney. A lot of people want to think that it's up to the judge to do what's right.
Yes.
So let me tell you something. That's not necessarily what the judge is supposed to do. Judges are supposed to decide conflicts and issues of fact and law. Conflicts and issues of facts and law. They're not supposed to bring up their own arguments to benefit one side or the other.
But they do.
Yeah. Well,
Well, sometimes they do.
Most times they do, Vincent. Not some. Most judges do.
So I think Georgette has been involved in a couple of cases. I've been involved in thousands of cases.
All right. You're right.
You pick who you want to listen to.
Listen to this.
in this particular case, the judge that we have is brand new to family law. She is actually a criminal justice judge that has been moved to a family law chair. And to move forward, they lost reunification, and then our plan was guardianship for the paternal grandmother. And she had started the RFA process. I was already foster parent approved. It took a while because of COVID, but I was always temporary. I have a 5-year-old myself, and I wasn't planning on raising my sister's kid for her. But I always had that in the back of my mind, that home is on Megan's Law, even though the grandfather does not reside in that home, and that's who's registered sex offender. He's 90 years old, doesn't visit the home at all. It's still, that address would still pop up. So that was always in the back of my mind, knowing that that's going to become a red flag eventually for placement. And I made that very clear to the social worker, who kind of just swept it under the rug. Alameda County did approve the home and for RFA, and they were aware of the situation, but I'm assuming granted it because grandfather did not reside there. He just used that as an address. When reunification services were denied, we switched social workers to the adoptive assessment and placement social worker, and a 3.26 hearing was set. This new social worker, I'm not sure the process of how social workers kind of go over each other or sit down and have a little conversation about the case and whatnot, but it didn't seem like that occurred with this situation. The social worker had a little conference with us. Paternal grandmother was watching the kid while I went to work, and had a little sit-down conference with us saying that paternal grandmother's not going to be getting guardianship, and that there's a 14-day notice of removal and placement change, based upon me being endangerment and neglecting the child by placing him in a home that was a known sex offender's home, even though the other social worker stated that she knew and left it in Alameda County's hands. We were all very devastated and in shock, didn't know how to approach it. I had given the original social worker a couple of names of family members who would potentially be willing to take on the child if there need be, but the paternal family was never given the opportunity to give names of family members or friends. And at that 14-day notice, the paternal cousin, who's a foster parent in Jamestown, their social worker from that county reached out to Fresno County about placing the child with them instead of having him adopted out, and they were never returned. They never got a return phone call back. They called multiple times, the social worker from that county, and they never received any phone calls or anything. The 14-day notice went for about a month and a half while they put the child on a website of adoption referral. And then I was told that there would be a transitional process where we would do a couple meet and greets with the adopted family, and that eventually, after about a month time frame, he would then be placed with them. But I would have the opportunity to meet this family and make an impression to where they would decide if they wanted me in his life or not. During this time frame, I also tried to let this new social worker know that everything was approved from the other social worker. I had text messages saying that paternal grandmother could watch him. I had text messages saying that she knew that the house was on Megan's Law, that she approved pretty much everything that was going on, but the social worker didn't want to hear it. She was making the decision that he was unsafe in my care, which is by far the truth. And so there was a random welfare check done. She had called me early morning asking for dental information of the dental office. I didn't get back to her because I was in training at work until that evening. And then the following day, she sent the police to my house and my mother's house, asking where the child was because I didn't respond back to her, which was incorrect. And then they decided that they were going to remove the child the following week, and with no transitional, because I was not cooperating with them, which was very surprising to me because the whole reason I was going along with them was to do the transition so that my nephew wasn't just abruptly taken from me, who's raised him since day one. They asked me for a day that they could come get him, and I was told not to voluntarily give them a date because that would be as if I was voluntarily telling them, yes, come get him on this day. I'm okaying it. So I told them, I'm not going to give you a date. I'm going to let you know that he's not available on this day because he has his doctor's appointment that he's had for months for his vaccines. And they said, well, then we're going to pick him up that morning so you can cancel his doctor's appointment. He's going to be seen by our doctor. And that just took me back because that was definitely not in the child's best interest. They specifically picked the day that I said not to pick, and they picked him up an hour before. They brought the police to my house. And I had filed with the Fresno County clerk an objection to removal and a 180. The objection to removal was denied. And also I filed a PAP, a potential adoptive parent, and that was denied because they wrote back saying that this is not the correct time to file these because there was no filings for removal by CPS. The only thing that did go through was the JV 180, which I didn't even finish because I had no idea what I was objecting to, like what court order I was trying to change besides them removing him. And when we went to court for the JV 180, it was denied with no bias because I hadn't filled it out correctly or it didn't make any sense. Since then, I have hired an attorney who has refiled for me. She's actually the attorney that used to be the child's counsel for that county. So she knows everyone, all the other counsels, and kind of has an quote unquote in. And she's the one that kind of told me that the judge is not an actual family judge. We filed a JV 180 to have him placed back with a relative because they put him with a high risk adoption. So people are only fostering him to adopt him, but my sister and the dad have not lost their parental rights yet. And then we also filed a parent de facto status. We went to court. It was all put together with the 3.266 determination of parental rights. And we were in court for about 2 hours debating over should he be placed back with a relative in the time frame, and then the de facto parent status, and everything went to briefing and then to trial. So now we are sitting at a trial for parent de facto status, which doesn't make much sense, and then also a trial for it to be placed back with a relative. Now, my question is, when is the time frame that CPS has not to contact family members to place them back with family? Is there, because that's what the judge was kind of arguing with, she doesn't know when CPS doesn't have to contact relatives anymore and just places them with an adoption family that they get out of their agency. And they also expressed to me that it was not a removal, it was a placement change, which doesn't make sense to me either. I mean, I'm more than willing to adopt him. My father's more than willing to adopt him. And then we have this other foster family that's cousins that's more than willing and has attempted to get in contact with them that they just completely ignore. Also, I found out last week that the social worker that was the adoptive assessment social worker no longer works for the Department of Social Services, and we have a new social worker. So now my question is, how do I approach this new social worker with, I would like to adopt him, or how do I get her to understand him to be placed back with a relative without causing any more angst?
Okay. Are those all your questions that you want me to answer?
And then how much do the parents write? How much do parents have say in where the child is placed if their rights are not terminated yet? So if do they have any say where he's placed? Little to none. Okay.
So let's back up because there's a lot going on in this case.
Yes.
The child was placed with you?
Yes.
Okay, so I hope you have a pen and a piece of paper or you'll have to watch this video replay. You need to read a section called Welfare and Institutions Code, section 366.26 N as in Nancy. N as in Nancy. Okay?
Mm-hmm.
Now, the social worker was supposed to serve on you certain blank forms to allow you to fill out to have a trial, a hearing.
Yes, the grievance forms.
No.
Oh.
No.
Okay.
Grievance forms are only administrative within CPS. They don't mean squat to the judge.
Okay.
Okay. So you need to read 366.26N and the related forms. You're entitled to a full hearing within 5 days of the removal or the request for removal. And if they didn't give you that right, I would argue to the judge or to the Court of Appeal that your rights were violated and the child should be placed back with you.
Okay.
There, and there's an old case. Some will argue that it doesn't apply anymore. And I think the name of the case was In Re Kenesha In or something like that, where it said that if a child's placed with a relative and you want to take that child away from the relative, they're entitled to a petition and a hearing, a jurisdictional hearing, and perhaps even a disposition. I think 366.26N may have codified that and modified that case, but you're for sure entitled to a hearing to prove that the child didn't have to be removed from you. Now, the judge that you refer to, I don't know who that judge is, and she was in criminal, you say. She's now in family. She's not in family. She's in juvenile court.
Okay.
So you're not in a family court. There is a family court.
Okay.
But they deal with divorces and custody and visitation and division of assets and liabilities. You're in a juvenile case, juvenile dependency case, and the Welfare and Institutions Code applies, not the Family Code.
Okay. Oh, that's good to know. I've been looking up the wrong codes.
Right. So you need to look under the Welfare and Institutions Code, and they call it the WIC, W-I-C. Right. That's where you're going to get your answers. Now, the code section that I just told you about, 26N, I would bet $1 that the county council knows about that section. They're highly trained individuals.
Okay.
But if you and your attorney don't bring it up,
They're not going to.
I don't know, right? And if this is a brand new judge to dependency, juvenile dependency, I don't know if she knows it, but it's something you and your attorney should be talking about and arguing about. I was involved in, or not, I wasn't involved in the case. I know of a case where they did this to a relative caretaker, and they took what's called they didn't get the hearing, and they took a writ. And the Court of Appeals, I forget how it went. I think the Court of Appeals actually, slapped the trial court on the hand and said, you got to give this lady a hearing. And by the way, pending the hearing, the kid has to go back.
Oh, okay.
Okay, I think that's how it went. I wasn't involved in the case.
Yeah.
A colleague of mine was, and he was telling me about the case. But when you read 2.6 in, you're going to say to yourself, oh, none of that happened. And, you have an attorney right now, I hope, right?
Yes.
So this is something that you and your attorney should discuss.
Okay. Is it normal for a de facto parent to go to briefing?
To what?
To briefing. So they took everything I filed to briefing. The judge admitted that she was new and that she needed to do her research.
Oh,
and that,
yeah. Well, that's a good thing. That's a good thing because the judge is willing to learn.
yes. Is it normal?
This area of law is so convoluted and complex. I admire a judge that says hey, we got to go to briefing. Now, when you go to briefing, though, you and your attorney need to be citing the right law.
Yes. And have the right case law, yeah.
Most judges, I don't know if this is true, but a lot of judges won't do their own legal research, right? They're going to rely on you and your attorney to educate them. I mean, if I was a judge, that's what I would do.
Okay.
Right? Let's see what Crystal's attorney has to say about this. And if Crystal's attorney is not citing the right law, I don't know what to tell you.
Okay.
Okay? So read that section, and there are several cases on this section. But yeah, you do have a right to a hearing. You personally have a right to a hearing. You have substantial rights that aren't being recognized.
Yes, I was actually told that by the social worker when I said I'm going to fight for my rights, and she repeated, said, "You have no rights. You're not part of this case." And I was totally taken aback.
And I tell people this all the time, and this is exactly why. I tell people, don't talk to the social worker, because they're going to tell you something that's either wrong because they don't know, or it's wrong and they do know and they're trying to mislead you. I've had social workers talk to my clients and tell them, you don't want to hire Davis, or you should fire Davis because he doesn't know what he's doing. Now, Crystal, I'm 63 years old, and there's one thing in life that I do know, and that's this area of law. I don't know a lot of stuff about other things, but I do know this area. Okay, but my law firm sues social workers, and a lot of social workers don't like me. I've represented social workers, and they come and tell me. It'll be crazy stuff, like when my name comes up. Oh my God. They have to sound the alarm.
I was on the phone with a client, remember, Vincent? And I heard the social worker telling her, do not hire him, that she would, make sure that she doesn't get her kids back.
Oh.
Yeah.
Now, I didn't hear that, but Georgette told me the story.
I heard it.
And the client later admitted it to me. And she says, look, Mr. Davis, the lady says if I hire you, I'm not going to get my kids back. I can't hire you. And you know what I told her, Crystal? I completely understand. Because you don't need me and the animosity people have against me to be holding you back. You got enough to worry about.
Yeah.
But see, that's the thing. They want to discourage people from hiring the right attorneys that understand state laws and understand state jurisdiction laws. So I guess with me, for her to say that, the social worker, she's intimidated.
Yeah, most definitely. You are
because you're smart. I call you the encyclopedia of codes. That's what
you know what? If this were a police case, Crystal, and you were charged with robbing a bank,
Mhm.
Do you think the police might be trying to intimidate you or
Mhm.
use the good cop, bad cop routine?
Oh, most definitely, yes.
Yeah.
Mhm.
Social workers do the same thing. As a matter of fact, a lot of people don't realize this, but social workers are highly trained governmental agents. Now, that's not to say they're trained for good, but they're highly trained. They can get information from you. They can investigate and find stuff you never would think of,
Mhm.
and they can manipulate the players in a case.
They actually write different. They actually manipulate the notes on the case
Oh, yes.
all
Chris-
the time. All the
Crystal,
time.
I'm going to tell you something that happened just recently. A few months ago, a judge awarded my client her kids back. And the social worker did not want that. And the children's attorney did not want that.
Hmm.
A few months goes by, and, things kind of cooled down, but we're going to come up to another hearing soon. The social worker calls my client, unbeknownst to me. And I told my client, don't talk to the social worker, right? But of course, half of the people don't listen to what I say. She
Mhm.
talks to the social worker. You know what the social worker allegedly told her? The social worker allegedly told her to call the minor's attorney and demand that the attorney come out to her house to visit her kids.
Mhm.
Now think about that for a second.
Why?
My client has no business telling a minor's attorney what to do.
No.
It's setting
So
her
that-
up to fail.
Right. It's
Setting
setting
her
her up for the minor's attorney to be
Mhm.
pissed off at my client.
Mhm.
You
Mhm.
see, a lot of things are manipulated in small degrees.
They lie.
And social workers know how to do that.
Oh, I experienced it. They are accusing me of sexual endangerment, and I'm the one that kind of was trying to not put him in danger and letting you guys know this. So it totally backfired on me.
Right, but you have a saving grace. You have the text.
Yes.
You have a social worker that you told.
Yes.
And despite that, that social worker said it was a safe place. Now, would I have said that? No. But what the social worker now is trying to do is correct that at your expense.
Yes.
She shouldn't be mad at you. She should be mad at that other social worker.
Correct.
Mhm.
Yes.
And she should just tell you, look, you can keep the kid, but don't let the kid around that house at all.
Exactly.
Ever.
Yes. Exactly.
And then, you seem like a reasonable person. You're not belligerent. And, okay, madam social worker, I'll do whatever you say.
That's exactly what I do say. Which now it's very hard to say that now when
Right. Here's one of the things also that a lot of people don't realize. Social workers are human beings. They have the same personality defects, character defects that all human beings have. All of us. So for people to think that social workers don't manipulate, don't lie, don't take things out of context, that's a fallacy.
Mhm.
One of the largest cases I ever won in suing a social worker, I got on videotape at a deposition, a social worker, after backing her into a corner, admitting to me on videotape that she lied about something, that she intentionally lied, and put it in writing to go in front of a judge. After that deposition, because I asked her 100 different ways, because I knew later they would try to slither out of it, right? The social worker's attorney tells me in private, you know what, Vince? Today you had more fun than any lawyer should ever have doing a deposition. Now,
Yeah.
do social workers ever lie?
Yes.
Yeah.
yeah.
Do people ever lie? Yeah.
But it's different. There's lies and there's lies, Vincent. There's lies that destroys a person's life.
No, the way, in my opinion, the way the legal system works,
Yeah, that's horrible.
is the truth is the truth, a lie is a lie.
Hmm. But they lie. They're pathological liars. They're like, I look at them. They have the same trait as Satan.
But here's what I'm telling you: don't be surprised. They're like people.
Yes.
They're like people. So don't be shocked. It's just, what are you going to do about it?
Yes.
You going to do anything? You're going to crawl under a rock and cry about it? Never
Well,
get
I
up?
don't think she expected me to get an attorney yeah, that's also was
Because you know how many people in your position get an attorney?
not many.
Not many at all. Not many at all.
They,
For many
they
reasons.
stick with the court-appointed attorneys, and which they don't do anything
Well,
other than.
I wasn't allowed an attorney, so
Well,
Yeah.
before we, demean all court-appointed attorneys, let me tell you something. I know some great court-appointed attorneys.
I don't
Really,
know.
I do. The problem is this, Georgette. You don't hear about the great attorneys because they don't need to call me, right? They don't need to call me. It's when they have a problem. But you know what? Court-appointed attorneys are like everything else in life. There's a lot of good ones, there's a lot of bad ones, and a lot in the middle. But that's true for everything. It's true for social workers, true for parents,
Social
true for
workers
true for judges.
and judges. Wow.
I've had parents or people tell me on social media who are parents that social workers don't lie, ever.
Mm.
I've had people tell me that kids being in foster home is the greatest thing since sliced bread. Because their experiences are different than your experiences. So we all come to conclusions based upon our experiences. Right?
You do know that social workers do lie, right?
I would say that some do, some don't.
Wow. Okay.
And Crystal, what I wanted to tell, maybe it wasn't you, it was the other guest earlier today. When you go to court, all right, and you don't win, that doesn't mean by definition that the system is corrupt.
Oh.
It doesn't mean that. It could mean that. It could mean a lot of other things as well. I tell this story all the time. I had a guy who went to court on a Friday, lost miserably, came to me on Saturday and said, "Hey, Mr. Davis, I want you to change everything. Wave that magic wand." And he began to tell me the story of what happened in court. And he said the judge was corrupt because the judge wouldn't look at his evidence. He had a stack of papers. And I pointed out to him that the judge shouldn't have looked at those papers because he didn't meet the evidentiary foundations to get those documents into evidence. You can't just show up and say, "Hey, judge, here's some papers, look at it and make a decision." It's hearsay. It's not properly authenticated. Okay, there's no foundation. But he didn't know that those were the rules.
What if it is probably? What if it is done correctly and the judge still refuses to look at the evidence?
I don't find those cases many times. What happens is, if it is done correctly, the judge looks at it and decides not to use it. Judges still, I was telling the last guest, look, once you get into court, that doesn't mean you're going to win. That doesn't mean you're going to win. Because judges have a lot of discretion and power, and they can make their own decisions. Now, you may not agree with it, but that happens all the time. And listen, in my 35 years, almost 35 years as a lawyer, I've won cases I never should have won. I've lost cases I never should have lost. Have I won cases that deep in my heart I knew I shouldn't be winning? Yeah. So, this whole system of justice, and we can talk about it theoretically for hours and hours and hours. Are there problems with it? Yeah, there are. But it's the best system they've developed so far.
There is no justice, Vincent.
So, until they get a machine that can tell when somebody's lying or telling the truth, there's
I-
always going to be, these decisions that might be wrong.
I have one last question. So the trial was set for overhaul. What does that mean?
For what?
Overhaul?
I never heard that term.
Oh, I don't know what it meant either. That it was set for the trial was set for overhaul.
Okay, you should ask your attorney. I've never heard that term before.
Okay. Well, she said that it was a new judge is going to take over the trial, but I didn't know if that's why that would happen.
I've never heard of that term before. I apologize.
No, something new for you to go look up now.
Were you doing this on Zoom or were you in the courtroom?
Of course, Zoom, definitely.
Right. So what happens a lot of times on Zoom? You think you heard something and it was something else.
Totally different. For sure, that's happened quite often.
The audio, even on this, during this thing, the audio for you, for me, for Georgette, it goes up in quality and goes down in quality. Guess what happens when it goes down in quality? I can't hear you really well.
Sounds like wah, 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 wah,
Right.
wah, wah.
Right.
Peanuts.
There's something I would like to ask real quick, Vincent, before the show is over. I got a lot of calls of grandparents stating that the social worker told them they have to be foster parents in order for them to get placement of the kids. Is that within the law that they have to be foster parents? Then
No.
why are they saying they have to be? And they actually do get their foster license so they can have placement of the grandkids.
Why do social workers say that? I don't know. They don't
I'm not
share.
saying what. Yeah, they're saying they asked if it's law, if it's the law.
So it's a little bit different. It's one of the ways the grandparents can get the kids. It's not the only way. And a lot of social workers, and sometimes I get the feeling judges, like that way better than other ways.
Why? So they can take the kid back and say they violated the foster parent code?
No. A lot of them are concerned that they don't want to place a child with a relative that might hurt a child. Believe it or not, social workers would get sued because they would place the kid with a relative and then the relative, was some kind of, danger to children and hurts the child. So imagine there's a wall and on the other side of the wall is the kid. You get the kid. And this wall has 5 doors, all right? Each door is different, but it will get you to the other side, right? So the become a foster parent door is the one everybody likes because it's the most conservative. It's the safest if you're the judge or the social worker, right? But there's another door. It's called relative placement, emergency placement.
You know what's amazing though? We had an investigator, a caller, had an investigator investigate a foster parent home, and a sex offender was living there. So I guess my thing is this: if it's such a safe haven for them, why do other foster parents have records? Why do other foster parents have criminal records from 20 years ago? And they're telling the biological grandma, you have a record from 35 years ago, but yet the foster parents has the same exact record. I guess that's the thing.
Because some people go through the process of getting an exemption, right? An exception to that requirement. I tell people this all the time, Crystal. If you're looking for logic and fairness in the law, you will always be frustrated.
So common sense doesn't exist in the court of law. So they're good on paper, but logically they're missing a screw. Is that what it is?
Only laws apply.
So case law.
Statute,
I've never, you know
case
what? I grew up with both my parents. I've never had problems growing up or having to deal with any of this. And honestly, I used to think the system works, but it doesn't work. The system doesn't work because
So,
there's great mothers out there, Vincent.
Crystal, you know, I disagree with Georgette. The
Okay.
system works a lot of the time. Are there times when it doesn't work? Yes. Yes. Are there times that it does? Absolutely.
This is insane.
I personally think the reason why the social worker is not part of the Department of Social Services anymore after working there for a decade is because I kind of brought to attention how she was proceeding with her adoptions and assessments. So
Mhm.
that's what also sucks is now that we have a trial set, my attorney says it may be difficult to get her to testify since she's no longer a social worker, part of the department, which
Well, if she's not, you should. First of all, you can if you can get an investigator and you can subpoena her, and she'd have to show up.
okay.
And if you're right, you'd want her to show up because she's going to be pissed off and probably help you out because she got fired. Maybe,
Okay.
maybe not. But what I would do, I would, if I were your attorney, I'd write a motion to exclude any report that she wrote.
We could do that.
Mm-hmm. It's called a motion in limine. And the other thing I would do is I would make a motion to get her personnel records to find out why she doesn't work there anymore. Because if you're right, that would be a bombshell for your case inside the courtroom.
Yes.
What if she just told that she was fired and she really wasn't? She was just moved to another department. I had
Well,
another
It
person that
was
told me
county
that.
council. It was county council that let my attorney know that she no longer works for the Department of Social Services.
But what you want to do is you want to see if that's correct.
Okay. So we file that with obviously the courts.
File the motion, yeah.
Yeah. Okay. We'll see if that gets granted. We filed for the disclosure, and we didn't get it. But
What do you mean?
we filed for the disclosure of records based upon the accusations of me and what was said about me endangering the child, but it wasn't granted. So we kind of buddied up with the father's counsel.
Did you file a writ or an appeal on that denial of getting that disclosure?
No, we went about now we're getting all of it from the father's counsel, and he's sharing the information with us, which probably, I don't know if that's legal or not.
It's not.
Okay.
You and your attorney can get in a lot of trouble.
Okay. So we've just appealed that?
Take a writ or appeal.
Okay. What's the difference between a writ and appeal?
A writ, W-R-I-T, is an emergency appeal that the court can or cannot decide on the merits. An appeal is a matter of right for you to have a court of appeals review a lower court ruling.
So that goes up a court.
Correct. Goes to a higher court.
And the writ stays at that same level.
No. Writ goes to a higher court as well.
Oh, well, then we want to appeal and with things. Okay.
That case I told you I don't know if I told you this, but I'm doing a case in Oregon. Today we had a phone conference with an attorney in Oregon who's an appellate specialist, and all she's going to do is all of the writs and appeals for the case, and there are several motions and stuff that we're trying to appeal.
Okay.
But
Well,
sometimes the appellate work can just take on a life of its own.
that's what I was going to say. Like, I filed for de facto parent status so that I would be financially helped with representation. They're denying it because of where we are at the case, thinking that I wanted the child placed with me because of that.
Okay, hold on. Okay, that's a bad reason to file the de facto, but if your de facto was denied, you should appeal it immediately or take a writ on it immediately.
Okay, well, we're briefing it. So.
No. Oh, the judge hasn't determined.
Yeah, no. Everything that I filed went to briefing, and then there was no 3.26 hearing made. Another one moving forward, which boggles my mind too. But I guess we have to
Well, you don't want another 366.
I know that. Yeah, but
So don't mention that to anyone.
I'm not. I'm telling father and mother, you guys are given an opportunity to probably do what you need to do, and then hopefully maybe get reunification services granted if you file for it. But I don't know.
Any other questions for me, Crystal?
No, I believe that is it.
Okay. Well, keep in touch with us. Keep in touch with Georgette and myself. And if you want me to talk to your attorney to give any input, I'd be happy to do that. Just have me know.
That would be awesome.
But he has to
Totally.
be willing to accept it as well.
Yeah, that's another thing. You know, a lot of attorneys don't want to work with me or
Yeah.
work with another attorney.
Oh, I think my attorney's willing to. She's pretty awesome.
Okay.
Okay. I will let her know.
All right.
Awesome. Thank you so much.
Thank you
And
for
thank you,
being on the
Georgette.
show.
You're
No
very
problem.
welcome.
Thank you.
All right, we've gone over time this evening. I want to thank everybody for watching us. Tomorrow's show at 7 p.m. Pacific will be the Civil Rights Show, starting to be one of my favorite shows. It's Fight CPS, the Civil Rights Struggle.
Mhm.
So tune in tomorrow on these same social media channels. And if you want some other resources that are free, go to my YouTube website or YouTube channel. It's Vincent W. Davis Trial Lawyer, I think, and I have hundreds of videos on CPS matters. And if you need a consultation or you need to talk to me or want to talk to me about hiring me, give us a call at 888-888-6582. All right, Georgette, I want to thank you again. Great show. And good night, everyone. We'll see you tomorrow at 7.
Good night, Vince.